Honorable Chief Justice and Associate Justices of the Supreme Court of California. Hear ye, hear ye, hear ye. The Honorable Supreme Court sitting on block is now in session. Please be seated.
Good morning. Welcome to oral argument. The clerk may call the calendar.
Good morning. The Supreme Court of California hearing oral arguments in San Francisco on Thursday, January 4th, 2018 at 9 a.m. Case number S231826, the People, Plaintiff and Respondent versus Mario Martinez, Defendant and Appellant. For Appellant, Ms. Cindy Beth Mishkin. And for Respondent, Mr. Warren Williams. Case number S237014, in re Roy Dinez Butler on habeas corpus. For petitioner, Mr. Sharif Jacob. And for respondent, Ms. Amy Feinberg.
Thank you. In the case of People versus Mario Martinez, we welcome the Honorable John L. Siegel, Associate Justice Court of Appeal, 2nd Appellate District, Division 7. Counsel, whenever you're ready.
Good morning. May it please the court. This case deals with Proposition 47, a law which this court is well familiar with, having issued many opinions within the past 2 years. This case specifically deals with the retroactive recall and resentencing application to Health and Safety Code Section 11379 transportation sentence. So first, it's important to remember the intent and purpose of the electorate when it enacted this new law, which was to reduce incarceration for non-serious and non-violent felonies and to apply the reduced costs savings to community-based programs to reduce crimes and help drug programs.
Are the crimes listed in the proposition?
The sentence for which recall and resentencing is requested?
Yes.
No, it is not one of the 9 enumerated offenses listed in the proposition.
But there are 9 listed.
Yes, there are 9 listed.
This doesn't happen to be one of them.
Yes, you are right, Your Honor. So as discussed in People v. Page, a recent opinion by this court published at the end of November, that list at the end of the 1170-12 resentencing statute describes how the resentencing is to occur. It does not describe eligibility. Eligibility is set forth based on a factual determination. This is known to us because this court first decided the eligibility question with respect to Gonzalez, where the court considered a burglary conviction, which is not in the list at the end of the proposition, and determined whether a recall and resentencing was appropriate under the new shoplifting statute, which is in the list. So the sentence for the conviction sought is not in the list, but the court found that it was eligible for resentencing as if it were a shoplifting conviction, which is in the statute. Similarly, in Romanowski, this court assessed whether 484E was eligible for recall and resentencing. 484E is not listed, one of the 9 enumerated offenses in the 1170-12 statute.
Counsel, I think I understand your argument,
Yes.
but let me ask you this question. This is what I'm trying to wrap my mind around.
Right.
Imagine that the proposition had been enacted at the time that defendant committed the offense. What then would have obtained?
Right. So that is the test. The proposition is transported back.
Exactly. So just walk us through how that cuts in favor of your position.
So the test, we can't take the statute in isolation. We have to take the statutes back in time and superimpose the statutes back in time when the offense occurred. And so here we have to take the 11377 statute back in time, knowing what happened to the understanding of the 11377 statute at the turn of the year before the electorate enacted Proposition 47.
And can you pause there? Why do we incorporate that understanding of what happened in the interim to the transportation statute?
Well, we're incorporating it to determine whether the conviction is eligible for resentencing, whether the sentence is eligible for resentencing. And we have to take it all in context. We have to know what the electorate intended when it enacted the proposition. And it didn't change 11.377, having known that the electorate changed 11.379 just 11 months before. It didn't remove the intent to sell element from the transportation statute.
But then we're not just taking the proposition back in time, we're taking other legal changes that occurred afterwards, right? And so I guess the question is, how broadly does the time machine operate?
Right. Well, the time machine has to operate broadly. It has to operate knowing what the law is existed when the proposition was enacted. If it doesn't operate that broadly, then we have just statutes picked out of context and sent back to 2007. We can't.
Can I ask you a question about this use of law? This offense was committed by Mr. Martinez in 2007.
Yes.
And you're asking us, in addition to rightfully applying Prop 47 to it, you're asking us to also apply a 2002 change in the law to the understanding of 11.377 and 11.379 to a conviction that was long final. And I'm not sure that I understand your authority for that step, to take the 2002 change and superimpose it on the 07 conviction, and then take Prop 47 and superimpose it on that context.
Right. Well, this statute makes a factual question.
Which statute?
The 1170-12 makes the factual question to determine eligibility, and after the after the legislature changed the transportation statute, then the only way to punish the offense that appellant committed would be through the possession crime. The only way to punish possessory movement of contraband after the legislature changed the statute would be through the possession statute.
I think that's certainly true prospectively, right? You're reading the law correctly prospectively, but the voters here chose a specific route for resentencing, and so there may be an asymmetry, but it's built into the statute. And I direct you to the language that says in 1170.18, it authorizes resentencing only for people serving felony sentence who would have been guilty of a misdemeanor under this act. Under this act, had this act been in effect at the time of the offense. And that's one constraint on the time machine problem, because it has to be a misdemeanor under this act. And Prop 47 enacted and also amended a certain set of statutes, but the one that you're concerned with was not affected.
Well, 11.377 was amended by Proposition 47.
But 11.379 was not, and that still stood as a valid conviction even up to the time that Prop 47 was enacted.
Right. Well, Proposition 47 does not attack the valid convictions. It just requests recall and resentencing. The burglary conviction that is resentenced as a shoplifting remains a burglary conviction. It is just merely resentenced as a misdemeanor as a shoplifting. We are not asking the court to invalidate the transportation conviction. The transportation conviction remains. But the act has to be construed in context. We construe all laws within the context that they are enacted. And the electorate did amend 11.377. It amended it to reduce the penalties. But when it made the amendment, it chose not to change 11.379. It chose not to exclude transportation crimes from its purview. And the electorate acted within the knowledge that only possessory movement crimes could be charged under that possession statute. So we have to take all of that context back and superimpose it on 2007 to make this eligibility test.
But as Justice Liu mentioned, the language of the initiative says under the act. Doesn't that mean under the act just initiated?
Well, yes, it does mean under the act.
Doesn't mean all criminal law, does it?
Well, you can't. You have to take the act in the context in which it was in which it was enacted, so that we understand.
Referring to the initiative that was enacted.
Right. Well, we had to understand what the burglary crime was and what the larceny crime was, with respect to shoplifting. And the court used all the prior litigation that had occurred to understand what the electorate meant when it used the term larceny in the proposition. Similarly here, we have to take the whole context in which the electorate acted in order to understand the application of this test.
Do the ballot materials help you at all? Walk us through, in a case like this one, it's not unusual when we're trying to think about the purpose and whatnot to think about the ballot materials. So
yes.
How does that help you?
Yes, the ballot materials tell us about the intent of the rule, the electorate, when it acted. And the intent was to reduce the sentences for these non-serious and non-violent crimes. But the ballot material doesn't say, well, we are going to reenact the transportation crime. It was silent on that. So the electorate, knowing that this possessory movement could only be prosecuted under the possession statute, knew that there was no intent to reinvigorate the transportation crime and eliminate the intent to sell. Also, when you look at the legislative intent, you're thinking, well, maybe the statute is a little bit ambiguous and we don't know exactly what this term means. Do we need to read the term so narrowly to only look at the specific isolated statutes, or do we need to look at the context? And any construction that would not take the entire context back and superimpose it back on 2007 would have an anomalous result. And that is that these possessory transportation crimes, offenses, that occurred after Proposition 47 would have a misdemeanor sentence. These possessory movement crimes that occurred after January 1st, 2014, when the legislature added the intent to sell element, would be eligible for recall and resentencing. But all those possessory movement crimes committed before January 1st, 2014, would not be eligible. And so there would be a very narrow subset of offenses that would not be eligible for recall and resentencing. And certainly there was no intent expressed by the electorate to carve out this exception, this narrow exception.
Under your reading of the transportation crime, is possession an element?
No, it is not an element. Possession is not required based on the Rogers opinion issued by this court in 1970. So we're not talking about elements. That's why it's a factual question. That's why it was a factual question in Gonzalez. It was a factual question in Romanowski. It was a factual question in Page. And so we're not just merely looking at whether the elements correspond. We're looking at whether the acts underlying the offense would make the elements of these new or modified.
I see that point, and you make some reasonable arguments. So the reason I think that complicates the argument, at least about the ballot materials, is that the ballot materials talk a great deal about possession. Mm-hmm. They don't talk about transportation. So you make some good points about the overarching purpose of the proposition, but there are, I think, ultimately some limits to how far that argument might go, perhaps, if one thinks about all the distinctions that are made in the ballot materials between possession and other offenses.
But then the ballot materials talk about changes that are occurring. There was no change to the concept that possessory movement at the time the electorate acted on the proposition was only punishable as a possession offense. So I think there was so much information needed to be conveyed in the ballot. I think that to require the analysis to also say, well, by the way, we're not changing the crime of possession as it existed at the turn of the year would be superfluous, would be not needed. That you really talk about in the ballot what active changes are being made. This was not an active change.
Can I ask you a question about that? Much of your context argument has to do with the electorate is presumed to know the law when they passed Proposition 47, right? If the legislature is if the voters are presumed to know the law, and they list, so they know the change that happened in the beginning of 2014, and they list the statutes that are going to be eligible for resentencing,
aren't they presumed, if they know the law and they didn't choose 11-379, then doesn't that really support the other side's argument that when the voters enacted Proposition 47, they knew the law and they knew exactly what they were doing, said, nope, not 11-379?
This list at the end of 1170-18 subdivision A does not prescribe what crimes are eligible for recall and resentencing. That list, as discussed in the Page opinion, sets forth how the resentencing is to occur. The resentencing is to occur in accordance with the listed statutes. The list can't...
If the voters are presumed to know the law, they chose the ones that would be, that people could get resentenced.
Well,
and this was not one of them.
There can't be a... Well, that's because this crime, this offense, was not a transportation offense at the time the list was created. The list talks about how the resentencing is to occur, but when this list was created, the transportation offense could only be punished as a possessory offense.
So wouldn't it be more accurate to say that it couldn't, insofar as the actus reus, the focus of the punishment visited on defendant was transportation, would it be more accurate to say that to the extent it wasn't for the purpose of sale, it wasn't at the time Prop 47 was enacted an offense at all? It's not that it had been reduced to a misdemeanor, it wasn't an offense because of that intervening change.
Well, the possessory... It was still an offense under the possessory statute. The only way for the government...
But possession wasn't an element that had to be proved in order for him to be convicted of the transportation offense at the time. Is that correct?
Yes, that's correct. Possession is not an element of the offense. However, we are looking at the test, which is whether the defendant would have been guilty of a misdemeanor under the Act, and based on the factual context, the defendant would have been guilty of the possessory offense when the defendant moved the contraband in the car he was a passenger in.
So that, I guess I'm wondering what authority we have for looking at the real offense conduct underlying a conviction as opposed to looking at the facts that gave rise to the conviction. So to the extent that the object of that initial criminal proceeding was transportation and possession was really sort of beside the point, can't we really look behind those facts giving rise to the conviction to look at sort of broader contextual facts that may not have been at all relevant to that prior proceeding in order to determine how Prop 47 applies?
No, I do still think you have to look at the facts to get the whole context to assess whether the defendant would have committed an offense that was listed at the end. Yes, an offense that was a possessory offense. I think you have to make that determination.
And in order to do that, we can look beyond the facts that gave rise to the conviction, and we can look at other facts that weren't required to support the conviction at the time it was entered.
Well, this was a fact that gave rise to the conviction because transportation, it's not a required element, but certainly the question of whether he aided and abetted somebody else to transport, or the question whether he actively transported himself and therefore had possession of the contraband is part of the consideration. So while possession is not a required element of transportation, it often occurs during the transportation. Just like with vehicle theft and 10851, joyriding sometimes occurs when the vehicle is stolen, but sometimes there's just a vehicle theft, and we have to look behind the acts to find out what offense the defendant committed.
I'm still stuck, counsel, on the first step of the argument, which is the transporting back in time, not to use the word transport, to move us back in time. To what would Mr. Martinez have faced at the time of the offense if Prop 47 had been in effect? At the time of the offense, 11379 would still have been in effect as well. Or are you asking us to not consider to consider that the amendment to 11379 as somehow incorporated into the time machine back travel.
Yes.
Are we to understand that 11379, as it stood at the time of his offense, is the proper counterfactual legal landscape to take into account?
No, you have to consider it all within the context, because the context of Prop 47, the context, and so therefore that context, yes, in that context, 11379 had been amended by the legislature.
But your argument is that when Prop 47 says, had this act been in effect at the time of the offense, you mean, had this act and all background law against which this act was enacted was in effect at the time of the offense? Is that what you mean?
Yes.
That's not what the text says.
No,
that's what you mean.
It would be too much for the text to say that that the idea to superimpose just the isolated statutes back in time to 2007 is a radical idea that is not contemplated in the criminal law context. Statutes are not read in isolation. Statutes are read in the context in which they're created. And so to understand the statute, 11377 possession statute, we have to understand the context in which it was modified. And that context is when the 11379 statute had been amended by the legislature.
So that was my question about your use of the 2014 amendment to a possession of 11379. And the way you get there is not to necessarily argue that that retroactively applies that statute to your client's conviction, but that Prop 47 took that into account when it decided that 11377 felony possession should be a misdemeanor possession.
Yes. Yes. And you have to do that, or else you get the anomalous results. You get the intent of the electorate knowing that this possessory movement offense should be a non-serious, non-violent offense, only a misdemeanor going forward. But then if you don't have this interpretation that Your Honor just talked about, then you have the same acts prior not being, the same non-serious, non-violent possessory offense not being eligible for the misdemeanor sentence. And that is not the intent of the electorate when it enacted this act. It intended a broad application of the retroactive resentencing provisions. And it did not intend to carve out this specific minuscule portion of offenses. And it would be, I think, too much to require the electorate to put in, well, we consider the act along with all the other law at the time. Of course we do. Of course we consider all of the legislation, all statutes within the context within which they exist. To take them in an isolated fashion, as the court is considering, would not result in a fair application, a broad and fair application of this resentencing statute for non-serious, non-violent offenses. With that, I will save my time for rebuttal.
Thank you, Ms. Mishkin.
May it please the court. Essentially, appellant seeks to use Proposition 47 in order to make the 11379 amendment retroactively apply to him, more or less. But the language of the statutes that were added or amended by Proposition 47 do not permit such an action. Unlike Penal Code Sections 490.2 and 459.5, 11377 did not contain any language that would incorporate other types of possessory offenses like transportation or possession per se.
Do you acknowledge at least that not providing relief here to, or not providing eligibility here to Mr. Martinez creates something of a asymmetry?
Any asymmetry that is involved in this case is not because of Proposition 47. The only asymmetry is because the legislature made a conscious decision to only apply the amendment prospectively.
To 11379.
To 11379 in 2014. So the fact that the defendant in this case could only be guilty of a misdemeanor 11377 now does not have anything to do with that amendment. It's a separate action, essentially. I think a good way to think about this case is the demarcation point is January 1st, 2014. Prior to that point, defendant's conduct in 2007 could be charged with 2 felonies, simple possession and transportation. Subsequent to the 2014 amendment, he could only be guilty of simple possession, a felony. Now, when we add in Proposition 47, and we take that back in time to 2007, he can now be guilty of a misdemeanor simple possession, but also a felony transportation conviction. If he committed that offense today, he could only be guilty of a misdemeanor simple possession. So essentially, it's not that the simple possession offense, 11377, incorporated the amendment. It's just that the conduct that appellant committed in 2007 is no longer in existence. He can only be convicted of the one statute, 11377.
Isn't it a fairly, from my view, reasonable explanation that the reason why Proposition 47 didn't list non-sale 11379 convictions, right, is because it didn't need to. It had already, that particular, right, 11379 non-sale transportation was already taken care of. So when you got to Prop 47, they didn't need to list that one because the problem was kind of solved, and maybe it was an oversight that they forgot to either in January 2014 pick up past convictions because they hadn't thought about Prop 47 stuff yet, right? Or when they did Prop 47, it's an oversight to think, wait, are there any other crimes that became misdemeanors that someone may, who's currently serving, may want to re-sentence, get a new sentence? So isn't really the reason why the explanation, isn't the explanation why Prop 47 doesn't include 11379 is because it really didn't need to because the legislature had solved that problem.
I think that's correct, because today, if that conduct occurred, it could really only have been charged as a simple possession. So there was no reason for the voters to incorporate any changes to 11379. Now, if they had wanted to also impact 11379 convictions prior to 2014, they could have easily done so in several different ways, but they did not.
Your supplemental brief lists 4 of them.
Right.
Right. But isn't it kind of like an oversight? And I guess the question is, isn't it an oversight we should do something about?
No, I don't think there's
to
any...
To avoid the asymmetry?
To avoid the asymmetry?
Yeah, which is not only in the amendment, but the asymmetry is also in Prop 47 because it neglected to pick up these kinds of convictions.
No, I don't think so, because the voters made a reasonable decision to limit relief under Proposition 47 to simple possession alone. Just as the legislature made a reasonable choice to only make the amendment to 11379 prospective and not retroactive. The voters are entitled to make those reasonable decisions, and sometimes the lines get drawn, and in this particular case, simple possession was all they wanted to provide relief for, and not other types of possessory offenses like transportation or possession for sale, for instance.
So you would say the solution is to go to the legislature and say, when you finish cleaning up what you started in January 2014 and add a Prop 47 component to it.
If they wanted to. Or if they wanted to also do so, they could have made their amendment retroactive.
What would be the rational basis for the electorate to have so finely tailored their eligibility criteria here?
One aspect comes to mind is that probably along the same lines that the legislature chose to make their amendment to 11379 prospective is likely because they did not want to go back and relitigate all types of possessory offenses to establish whether or not there were other elements that were not necessarily required to be proven at that point in time. And I think it would be reasonable for the voters to make that same conscious decision that we want to limit this to simple possession offenses and not relitigate other types of offenses.
So the voters were attributing to them some sort of rationale that they didn't want, in this particular case, to litigate whether or not Mr. Martinez actually possessed the drugs. He was convicted of transportation, didn't require proof of possession, but you don't want to peek into the facts to look at whether or not he possessed. drugs?
Well, I think it's important to keep in mind that
Is that any more onerous than peeking at whether theft involves less than $950?
proving an element of the crime that wasn't necessarily at issue 10 years ago or 15 years ago would be vastly more difficult to find witnesses to try to prove up that extra element. A lot of times in a property theft case, it's somewhat easier to value the stolen item because usually we know what the stolen item was. So improving the intent to sell in this case could be substantially more difficult.
Perhaps, but just to back up for a moment, ultimately, we're talking about, high level of generality. We're talking about relief being provided to a certain group of people who are offenders, and that can be done in different ways. It can be done either by conditioning that relief on the basis of how we define offenses now or how we defined offenses at the time they were committed. Both are valid from a policy or a penological perspective, I gather. Your argument is not that one is completely irrational and the other is not, but rather that given the statute we have here, the best way to read it is a particular choice was made, not that, one of these choices is completely so crazy that we can't imagine that that's what could be done.
That's correct. They could have made that reasonable decision to incorporate other offenses. And in fact, if they wanted to, they could have easily included any type of possessory offense, somewhat akin to the 490.2 where they said any possessory offense where the quantity of the methamphetamine is less than a certain amount, even possession for sale. They could have created a large umbrella crime like 490.2 if they wanted to do so. But they did not. They simply wanted to make relief available only for simple possession itself. And so 11377 does not contain the language like 490.2 as we saw on Page, nor does it contain any kind of language that would preclude also charging a felony at the time of the offense. So in Page, the 10851 could not have been also charged as a felony instead because basically the 490.2 language says that any theft that's with a value under 950 constitutes this new 490.2 crime.
Your point is that had Prop 47 contained language that says something like any possession or any not-for-sale drug possession could be charged only as a misdemeanor, then that would be more like the theft case. But that's not what it says. It says it actually amends particular statutes that are possession statutes.
That's correct.
But that returns us to Justice Siegel's question, which is they had no need to write that broadly because there was nothing else left at the time that they wrote Prop 47.
Nothing else left as far...
Meaning the transportation statute had already been taken care of. I mean, is there any other statute that is out there that might criminalize a possessory offense for drugs other than the simple possession statutes and then the transportation statute? And the question was the transportation statute had already been amended so that what Mr. Martinez did actually wouldn't even be a crime, right? Absent proof of intent to sale. It wouldn't even have been a crime. So the voters had no need to write any other language into Prop 47 except to amend the possession statutes because that's all there was left.
I disagree. There would have been a possession for sale. If a person was standing on a street corner with the same quantity of methamphetamine that the defendant in this case had in the floorboard of the car, that would not be encompassed under 11377. There's an extra element. Or if the same defendant were manufacturing a small quantity of methamphetamine for personal use.
But, I mean, I'm talking about the range of things that are possession, not for sale. I mean, of course, for sale, we already know that's in a different category. Nobody intended to address that in Prop 47. But in the not-for-sale category, right, are there any other statutes other than what we have in front of us that could have possibly have been affected, that the voters could possibly have affected through Prop 47?
Any other possessory?
Yeah, not for sale. That is the
I think it would be very limited. Yeah, I think you're correct that there really aren't too many other types of, I mean, basically there were 3 statutes that were amended under Proposition 47, and that pretty much encompassed all of the simple possession offenses that were available.
In other words, I mean, the point is if the voters wanted to demonstrate comprehensiveness which they did through the theft provision by the use of the word any, right? You could argue that they comparably did so in this context because they took care of the universe of possible problems that existed at the time Prop 47 was enacted. Namely, only those possession statutes, right, that criminalized not-for-sale possession that were then in effect. There was nothing else because 11379 had already been amended to not criminalize non-possessory transport, not-for-sale conduct.
I agree with you. And today, there really would not be a transportation for personal use crime. But when you look at the language of what do we do back in 2007, 11377 does not get us there. 1170.18 subdivision A says we have to look at the time of the offense, whether the defendant would have been guilty of a misdemeanor under the act had the act been in effect at the time of the offense.
But here there's, I think, a little ambiguity between the act. What do we mean by the act? Do we mean the act only in the bare letters of the act, or do we mean the intent of the act, right? Normally we say we construe a statute or we construe an act in order to effectuate its intent. The language is the best clue, but it's not in and of itself what we're effectuating. We effectuate the language in order to effectuate the intent. And if you say, well, the language here is indicative of an intent by the electorate to essentially make eligible for resentencing all not-for-sale possessory drug offenses, right? And they did that because they exhausted the universe of possible statutes they could affect with respect to that in Prop 47. Then, when you take that intent back in time, it would seem to touch the very conduct that is at issue in this case, would it not?
No. It says the act, and you would have to resentence in accordance with the act. There are 9 statutes that were amended or added by the act. So really, when we use 1170.18 subdivision A, we have to look at the 9 statutes.
That's just for pronouncing the sentence, though. I mean, that's a separate issue. I think we already clarified that on the page.
But
so your argument is that we don't take the intent. Well, I don't know even if you agree with my first premise, which is that the intent of the electorate in Prop 47, if you follow Prop 47's directive to give this enactment a liberal construction, right? Wouldn't you have to say that the liberal construction of the act is that the voters sought to provide resentencing eligibility to all defendants, right, who were convicted of not-for-sale possessory drug offenses that were, that they at that time could have committed, right? That kind of conduct, essentially, is eligible, for resentencing. If you agree with me that that was the intent, then the next step would be, does that intent get transported back to 2007? And then if it does, then it becomes even a harder question why it doesn't cover Mr. Martinez here.
I agree with you that the intent was to provide relief for simple possession offenses. And Mr. Martinez did receive that relief for his simple possession conviction. But there was no language that could have incorporated other types of possessory offenses. So in the ballot materials, it said we are providing relief for certain offenses that would encompass these 9 theft or drug-related offenses that were added or amended by the act. So even though there was an intent to provide relief for simple possession crimes, it did not provide any means through the 3 statutes that were amended to become misdemeanors, the drug statutes, to incorporate other types of offenses that may involve possession as well. It simply is not available to us, and that the voters made a reasonable decision to limit that. Even though there was a general intent to provide relief for simple possessions, they did not extend that to other types of crimes that also may involve simple possession.
Can I ask you, so my understanding of your argument is, Ms. Mishkin argues that when Prop 47 was enacted, it included the amendments to 2014 to 11379 regarding possession, and that when the language of Prop 47 speaks to had this act been in effect at the time of the offense, we have to superimpose Prop 47 and the 2014 amendment on 11379 and find that to be 11377 and reduce it to a misdemeanor. But I understand your argument to be, well, that's one possible interpretation. However, Prop 47 explicitly states, number one, the charges that it reduces, and those charges are purely possession charges. There is no intent to the voters that they are also reducing not for sale possession cases. And anyway, Mr. Martinez's conviction in 2007, there was no possession issue. So therefore, that's why Prop 47 doesn't apply to transportation 11379 convictions in 07. I mean, that's what I understand you're saying. You're looking to the language of Prop 47, what it told the voters, what we know it did in terms of possession. And then we look at factually, as Ms. Mishkin asked us to look at, Mr. Martinez was not convicted of possession. There was no issue of possession. If there was required proof of possession, that might have been the case, and maybe the council at that time would have fought for that, but we don't know that. So that's why in this particular case, there is some ambiguity, but the explicit text of Prop 47 doesn't fit the factual context of Mr. Martinez's conviction.
Yes, I agree with that.
He was convicted of possession.
Oh, I understood your comment to be about the intent to sale.
Yes. I know
Yes.
he had two, and I'm not talking about that. In fact, the court did reduce that to a misdemeanor, I understand, at the trial court level.
Yes, that's
Was
correct.
there any other basis for his possession conviction that was not also the same basis for the transportation conviction here?
Well,
Possessed it and he transported it, but he did it all at the same time, did he not?
yes.
So I guess I'm kind of wondering, first of all, do you have any idea of how many people this affects?
Potentially very many. I mean,
You think it's a large number?
I think it could be.
Large number of people convicted of 11379 transportation offenses in the not-for-sale context that might have involved only simple possession. That's a large number?
The reason I say yes is because the intent of the legislature when they amended it was to begin to preclude that double charging. And I think they were focused on the prison population and reducing that to some extent, prospectively. So that led me to believe that, yes, it was a large number for them to take that step.
Okay. And so your primary argument then is not really that the conduct that suppose it is true here that Mr. Martinez did possess the methamphetamine, and that's really the basis for both the transportation and there's no proof of intent to sale, at least that we know of now. And it's the basis for both the transportation and possession offenses. Your objection is not really to the idea that his conduct is somehow more culpable because it was charged as transportation. Your argument is really that it's a hassle that the voters wanted to avoid, to reopen these cases factually, and that it couldn't be done so many years after the fact to accurately determine whether or not the fact of possession actually obtained. It's not about, in other words, what I'm saying is it's not a fairness argument. It's actually just about the hassle factor. Is that what you're saying?
I'm saying that's one factor that the voters could reasonably decide. I think another factor is that transportation offenses can involve a large range of conduct.
Right.
Pre-amendment, it could have involved even walking down the street with a usable amount.
Yeah.
And that's one reason the legislature wanted to prevent overcharging. But also, a lot of the conduct did involve vehicles, which could involve other types of conduct, like being high at the time of driving the vehicle or driving near schools. I think there is a reasonable rationale for the voters to decide they did not want to disrupt those types of offenses, transportation in a vehicle in various parts of a city.
I see. So it was a tool used to perhaps get at other conduct, but it fit into the box of transportation of drugs.
I'm sorry?
You said something like driving while high. That's
Right.
not transportation of drugs per se, but it often involves transportation of drugs.
It could
So
involve
you
that same conduct, yes.
charge that particular crime, but it is associated with other conduct that we want to prevent or punish.
Yes, that could have been a reasonable rationale for the voters to exclude other types of possessory offenses. In sum, Proposition 47 did not turn every possessory offense, like transportation or possession for sale, into simple possession. That was a reasonable decision for the voters to limit Proposition 47 relief to simple possession alone and exclude other types of offenses, like transportation, just like it was reasonable for the legislature to make their amendment prospective only and not retroactive to convictions prior to 2014. If the drafters of Proposition 47 had wanted to incorporate other types of possessory offenses like transportation, there are several ways that they could have done so. But instead, they manifested an intent to limit relief to simple possession alone. And for that reason, the appellant in this case cannot obtain any relief. Unless there's any further questions, I'm prepared to submit.
Thank you, Mr. Williams.
So the electorate could have chosen any time in which to assess eligibility. It could have chosen acts that would be misdemeanors where they commit, if we look at whether the acts were committed at the time Prop 47 was enacted. It could have looked at the time when the sentencing occurred in the case. It could have looked at the time when the conviction occurred in the case. It took the pinpoint time of when the offense occurred. And it did not do so in order to limit application of Prop 47 and to carve out this transportation crime from obtaining relief, resentencing relief. It merely chose the standard point at which we look in criminal law to assess what punishment to impose. We choose in criminal law to look at the law as it existed at the time the offense occurred. That's just standard. And this is what the electorate chose. There's no indication that the intent was to unravel.
I understand the logic behind your argument that transportation is now possession. But in order to rule in your favor, don't we have to rewrite the statute?
No, we don't have to rewrite. We need a broad and liberal construction, as the electorate tells us that we need to make, but we need to...
But the statute is pretty specific.
It doesn't say, it doesn't say had only this act been in effect at the time of the offense. It just says had this act. And with that language, had this act, it's a broad understanding of the context in which the act existed.
Could I ask you about the inferences to be drawn? I go back to Justice Siegel's question about the idea that, I mean, your point of view, I take it, is that the electorate exhausted all the possibilities for reducing this kind of conduct because it addressed the simple possession statutes and it did not need to address anything else, because that's all there was to address at the time that Prop 47 was enacted. That's
yes.
Right? Right. How are we to distinguish that inference from the inference that no, actually, they could have chosen more specific language, as your friend on the other side says. They could have actually said, not only these three statutes, but also for any transportation conviction prior to, the 2014 amendment, because they should have been aware. Your argument is that, well, we can't expect the electorate to, write so precisely and so so much in the weeds, but how are we to distinguish those two things? Because I guess that goes to the further question of, wouldn't the electorate? What do you think of the arguments made by opposing counsel? The electorate might have had a rational basis, actually, for distinguishing the latter set of offenses, those transportation convictions prior to the amendment, from the other simple possession statutes that they actually did address.
Yes, Well, there was no indication that the electorate intended to actively not apply its indication that this type of offense was a non-serious, non-violent misdemeanor offense only within the limited context. The electorate had no indication that it made this judgment call to have it only apply from 2014 onward.
Does the ballot materials speak of simple possession?
They do, and
Right.
at the time that the electorate considered this question, the possessory movement of contraband without intent to sell could only be punished as simple possession. And as you notice, this defendant was punished under simple possession, and he did have the double charging that the legislature attempted to eliminate when it added the intent to sell element to the transportation statute. I don't think we're adding another layer to the lawmaking process, whether it be from the legislature or the electorate, to say, well, we intend this law not to apply to these prior crimes that would fit into the tests that we created, but we want these not to apply. We're requiring the legislature to say that.
What do you think of the hassle factor argument, which is that maybe in this case it might be easy. I don't know. I mean, I haven't really looked. There have been some claims made about what can be shown here, but we're not even there yet in this case. But what do you think about the mine run of cases? Is this hassle factor of proving up possession, or actually proving? I should also add, I guess, intent to sell, because that was not at issue, right? And so the other side may come in with something like that as well. Are we going to have to relitigate all these cases on the basis of facts that weren't germane at the time of charging and prosecution and trial of the cases, because everyone had their settled expectations about what they were going to face in that trial, and now we're going to bring everything back into play again and retry all these cases?
Right. No, I don't think there's a huge hassle factor. There are only a few cases up on grant and hold under this case. It is not the number of cases that we saw for the theft offenses.
Do you know how many?
I think 3, 4.
Okay.
And the hassle factor would be much less than we will see for some of these theft crimes to prove valuation. You're going to need to bring in experts, or for the access card, that will be a specific type of expert, access card information, specific type of expert that will need to be brought in. These types of offenses, the possessory movement, it'll be pretty easy. You can bring in the police officer, you could bring in the trial transcripts, payo sheets, you can bring in, if there's evidence and payo sheets, how much of the contraband was possessed. It's fairly basic.
This is 10 years ago now, though.
Yes, 10 years ago. Right, but it was a very small indication, a part of piece of methamphetamine. There was no packaging associated with that. There was no indication during the trial that there were any payo sheets. There was no claim by the co-perpetrator, who actually was not charged, claimed that the drugs were hers.
Right, but they weren't on notice. They had to prove the intent to sell.
No, but
it's like in the theft cases for 950.
Mm-hmm.
You look at, and I've seen some of them, you look at the record, and there's just no indication of even how many items were stolen, how much they were worth. Putting aside the access card cases, that's a little different.
Right.
But they weren't on notice. They had to prove up how much whether the items stolen were above or below 950. And here, yes, there's no evidence of all the things you're listing, no scales, right? Mm-hmm. Because no one knew they had to prove that.
Not in this case, but in some cases there may be evidence, and the jury may have said, no, there's no intent to sell. You don't know. But from the evidence, we know that this was a very small piece of methamphetamine packaged individually. That type of evidence, not much more would be required.
In this particular case.
In this particular case.
Your interpretation may be right for a number of reasons or not, but it does seem to me that when one goes from thinking about this individual case to how a ruling on this issue would affect the general pool of cases, there are at least some challenges one could imagine encountering. No?
Yes, there have been some challenges. In San Diego alone, we had over 200,000 Proposition 47 petitions to handle right after the law changed. But the courts are equipped to handle this type of question, and it's not a huge batch of cases that will be addressed.
In terms of the size of the number, I mean, the Attorney General says that it could be a large number. You mentioned only 3 or 4 grant and holds, but based on your understanding of how, I wonder if you have any understanding of how 11379 was used in the past. Was it used to get at a fairly broad swath of conduct that might be affected by your interpretation?
It was used to increase the punishment for these people who were moving with contraband on bicycles, in cars. It had a higher triad possibility and a mandatory felony sentence possibility. Of course, you could have probation, but it had the 2-3-4 triad rather than the wobbler determination, and so it was often used to charge up
Ms.
cases.
Mishkin, your time's expired.
Thank you.
Thank you, counsel. The matter is submitted. In the matter of In re Roy Finnis Butler on habeas corpus, we welcome the Honorable Lawrence D. Rubin, Associate Justice, Court of Appeals, 2nd Appellate District, Division 8. And when you're ready, counsel, thank you.
May it please the court. The stipulated order should be modified because legislative changes have ended the board's term-setting role and emptied the order of any ongoing meaning or function. In 2013, when the board and Mr. Butler settled this case, the penal code required the board to set parole release dates. The board implemented that requirement by providing life inmates with what's known as a base term, and that's an administrative calculation that marked an inmate's minimum term of confinement. Under the stipulated order, the board is required to provide that base term calculation to life-term inmates at their initial parole hearings and to promulgate regulations codifying that practice. But 2 years after the settlement in 2016, the legislature repealed the requirement that the board set parole release dates. And instead it provided that minimum terms would be set by statute. These legislative changes rescinded the board's authority to set base terms and made the calculation of base terms an idle act.
Rescinded the board's authority or rescinded the board's responsibility? Is it your argument that the board could not, in its discretion, say, we find the calculation of base terms useful in what we do, and so we'd like to do it, and the answer would be no, they don't have the authority to do that?
The legislature deprived the board of the authority to set base terms.
What does that mean, though? I mean, if, let's say, a majority of the board want to just take out pen and paper and calculate base terms, are they prohibited from doing that?
The statute does deprive them of the authority to do that, Your Honor. SB 230 specifically deleted the language that was in former Section 3041A that authorized and indeed required the board to set parole release dates.
I don't want to get hung up too much on this, but I just wonder if you need to insist on that to have your argument prevail. In other words, it sounds to me like you're making an argument now about just the power the board has to do something if it wants to do it. And I don't know, maybe there are ways that you can prevail where the argument is simply the board didn't need to do this, the board doesn't want to do this, the board doesn't have to do this.
You're absolutely right, Your Honor. The board can prevail on that ground alone.
Okay.
And the legislative changes, in addition to depriving the board of authority, emptied base terms of any meaning or function. Under the old system, before SB 230, base terms marked the point, the earliest possible date at which an inmate could be released. The legislature made the decision that that minimum term should now be set by statute. So a base term calculation provides no relevant information and has no purpose in the parole process at all.
Can I ask you, so it remains the case, as I understand it, that the board still has to consider the gravity, quote, the gravity of the current convicted offense or offenses in making its suitability determinations. Is there any conceivable relevance in the base term calculations to providing some measure of consistency and avoiding arbitrary individualized results in carrying out that function of considering the gravity of the current offense?
No, Your Honor, there is not. The board is aware of the circumstances of the offense at the time it considers whether an inmate is suitable for parole, but the legislature has made the decision that the board's paramount duty is to consider whether in an individual case the individual circumstances are such that the inmate poses a continuing danger to the public.
Would the board have the authority to promulgate some set of procedures to ensure sort of that like cases are treated alike in making suitability determinations?
Your Honor, the board and this court explained in Lawrence that the suitability determination turns on individual considerations and does not call for a comparative analysis of an inmate's length of confinement as compared to other similarly situated inmates. There are protections in the system, however, Your Honor. These individualized determinations have to be grounded on some evidence. And under the statutory structure, each inmate has an expectation of getting parole unless there is reliable evidence that he remains a danger to the public. And so the kind of data point that a base term used to provide does not assist in the board's current role in only considering suitability.
So how does the board operationalize the instruction to consider the gravity of the offense? Does it consider it only in terms of the individual characteristics of the offense, or does it also consider, sort of as a more categorical matter, how serious was the penal code section of which this person was convicted?
Well, the board a person cannot be released on parole until he has served the minimum term. And the statutory minimum does provide some measure of treating like cases alike. So, for example, all first-degree murder offenders are not eligible for parole until they've served 25 years, but of the lesser crime of second-degree murder, those offenders are eligible for parole after 15 years. So the system does provide some measure of accounting for the gravity of the offense based on the statutory minimum. But the suitability determination turns on a range of factors, and for, as the court explained in Lawrence, for the circumstances of the offense to bear on the suitability determination, there has to be a nexus between the facts and circumstances of the offense and the determination whether the inmate is currently dangerous at the time.
But in exploring that nexus, counsel, is it not possible for the board to consider how that nexus may exist or not exist in other cases that are similar?
Your Honor, no. In Lawrence, the court made clear it's an individualized determination, and that was the judgment of the legislature in providing that for this class of serious violent offenders who are exposed to the possibility of a life term, the question of suitability turns on the individualized characteristics of the offender and the offense.
I understand the term individualized determination, and I think in a way we're trying to explore a little bit more the scope of that term. So if we accept, of course, that an individualized determination is what's undertaken, I'm just trying to play out in my mind what it means if, say, one member of the board says, well, in making my individualized determination here, I'm just taking into account a variety of factors in accordance with the statute, but I'm also weighing the fact that this seems a lot like case B, which we dealt with, 7 days ago, and that weighs on me. Does another member of the board then say, that's illegal, you can't do that?
Your Honor, I don't know if that particular conversation would occur, but Lawrence did make clear that the legislature directed the board that the suitability determination turns entirely on the individual characteristics of the offense and the offender and his individual suitability.
I don't want to press this point too much, but then just to be clear, it sounds like your definition of individualized determination is not only that something has to pivot on the circumstance of a particular case, but that judgment cannot then take into account other cases and still be called an individualized determination.
It is focused on the individual and does not call for a comparative inquiry. And that was the judgment that the legislature has made in directing the board not to release an inmate unless, based on the individual circumstances present, he is no longer a danger.
But it would be consistent with that instruction to have something maybe akin to the federal sentencing guidelines, something that sort of structures the exercise of an inquiry into case-specific factors, but leaves discretion for departure based on, individual circumstances of the case that may not be accounted for. The guidelines. The suitability determination is structured. The legislature has defined it in terms of measuring an inmate's current dangerousness. The board has regulations that lay out specifically the factors that bear on suitability and bear on unsuitability. And I think it's important that even if there were some need for uniformity, base terms would not provide that under the current system because, number one, there isn't any authority for them, and number two, they previously were an effort to mark the minimum term of confinement so that individuals who committed their offenses in similar ways would serve a similar minimum term. That has been eliminated from the system. And so base terms don't provide any kind of benchmark today that they may have under the prior system.
Is that the only reason you think that the legislature, in addition to other changes in the law, got rid of the base term calculation? Or were there other concerns that the legislature then wrote in and deleted that portion of the statute requiring the board to calculate the base term?
Your Honor, the legislature believed that the base term system that the board had created was confusing, was opaque, was convoluted, and that it resulted in retaining inmates in prison longer than was appropriate, past the point at which the board had found them to be suitable. And for those reasons, the legislature decided to get the board out of the business of setting terms entirely and to focus the board's mission entirely on making these individualized suitability determinations.
The order denying modification addresses the constitutional issues, and as does the stipulation that produced the 2013 order. Is that a factor for us to consider?
Your Honor, the stipulated order does not express any agreement on Mr. Butler's constitutional theories.
Stipulation does. The stipulation makes reference to petitioner's constitutional claims. I agree with you, the order does not.
The stipulation acknowledges that Mr. Butler alleged a constitutional claim, but it did not express the board's agreement with those constitutional theories. And the board's rejection of those constitutional theories has been clear throughout this litigation. And we think it would be entirely implausible to read the stipulated order in the way that Mr. Butler has to infuse base terms with this kind of constitutional significance. The stipulated order requires the board to set base terms according to the matrices that the board promulgated in response to its prior authority under Section 3041A. And those matrices, by design and in fact, set minimum terms only. So it would be highly implausible to then infuse into those minimum terms a meaning of constitutional dimension.
And this court should basically disregard then that portion of the order denying modification that deals with constitutional issues?
Your Honor, we think the court should expressly reject that understanding of the meaning of base terms There have been, and we assume will continue to be, a number of claims in which inmates claim that their sentences have exceeded constitutional limits because, by mere fact, that they have surpassed their base term. And we think it would provide important and helpful guidance to lower courts and litigants for the court to make clear that base terms do not have a constitutional component. We also, I would also note that the Constitution itself doesn't require the board to fix maximum terms, as Mr. Butler has argued. The court rejected, and correctly so, that requirement in Dannenberg, and the system under which we are operating today is entirely different from the one that existed at the time that the court imposed such a requirement in Rodriguez. Most importantly, today, life offenses or life terms are reserved for serious violent offenders, and those offenders have an expectation of parole once they've served their minimum statutory time, and unless there is evidence of current dangerousness, and there is a ready mechanism available to deal with any cases in which an individual does believe that he has been confined past the constitutional limit.
If this court were to conclude that the Court of Appeal abused its discretion, should this court vacate the order, or should it remand it to the Court of Appeal, and if so, for what purpose?
No, Your Honor. The court should reverse and order that the stipulated order be modified. The Court of
Modified how?
Modified in the way that the board proposed, which was to replace the obligation to provide inmates with a base term calculation with the obligation to provide the inmates with their minimum eligible parole date provided by statute. And that is because today the statutory minimum eligible parole date is the functional equivalent of base terms under the prior system. The last point I would note, Your Honors, is that continued enforcement of the order is inconsistent with the public interest. It is wasting public resources. It is injecting confusion and uncertainty into the system, and it has, without providing any countervailing benefits to inmates or reviewing courts. When the stipulated order was entered, base terms provided inmates with the knowledge of their earliest possible release date. Base terms no longer serve that function, and so base terms calculations don't provide inmates with any useful information. They also don't help courts in reviewing any claims that an inmate might bring following the denial of parole. They don't cast light on a constitutional challenge that an inmate might bring, and don't provide any other useful data.
Counsel, I certainly understand the argument you're making that base terms don't serve a purpose anymore. I want to understand a little bit more your point about resources. What resources are involved in calculating base terms? Just say a little more about that argument.
Your Honor, the calculation itself is not particularly time-consuming, but this is a large system. There were 1,600 initial parole hearings last year, and the rejection of the board's motion to modify apparently sets the board on a course of having to calculate these base terms apparently in perpetuity. There has also been confusion and uncertainty because when inmates are receiving these base term calculations, they have been misled into thinking that they have some legal significance, and we have seen habeas petitions premised on that misunderstanding of base terms. And those costs just can't be justified given the absence of any benefit to an inmate.
That's a helpful clarification. Sorry to cut you off, but then you're saying that the downside is not really just the amount of paper, as it were, that is consumed or the amount of time in the calculation, but the expectations that are created and the misunderstandings and the potential confusion.
Your Honor, that is certainly the case, and it's also the case that modification is necessary here to conform the board's practices and the system to the direction that the legislature has given. The legislature has repealed the authority, at a minimum, directed the board to take a different direction. And we think it is important for the board to be able to conform the system and its practices to that clear direction from the legislature. If the court has no further questions, I will reserve my remaining argument for rebuttal.
Thank you, Ms. Feinberg.
Good morning, Your Honors. My name is Sharif Jacob of Kecker, Van Nest, and Peters, and I represent Roy Butler. Mr. Butler respectfully requests that this court affirm the Court of Appeal for one simple reason. The board has agreed to a stipulated judgment to settle Mr. Butler's action, and the Court of Appeal did not abuse its discretion when it concluded that the law upon which the settlement order was founded has not changed. 6 years ago, Mr. Butler filed a habeas petition challenging the board's practice of refusing to set a base term of imprisonment until after a parole suitability finding. That was the relief that he sought in his habeas petition. Mr. Butler alleged that the failure to set a base term violated the proportionality requirements of the federal and state constitution. Both parties faced risk in that litigation, and both parties decided to settle that litigation through a consent decree, a voluntary consent decree. Mr. Butler and the parole board stipulated to a settlement order vindicating the constitutional rights of parole-eligible life inmates and to have their base term set promptly. Now the parole board seeks to modify that settlement agreement based on a mistaken premise that Mr. Butler sought to vindicate a statutory right. That was never the cause of action that he sought to vindicate. This court should affirm the Court of Appeals ruling simply because it did not abuse its discretion when it found that the law upon which the habeas petition was granted.
Counsel, what if, for the sake of argument, I accepted almost all of your premises there, but then directed you to tell us exactly how setting a base term vindicates the constitutional proportionality interest?
Yes, I will answer that question, but let me just make a preliminary point, which is that I do not believe that this court has to decide the merits of the litigation in order to uphold the consent decree. The consent decree was entered after the parties voluntarily agreed to forego an adjudication on the merits. So the question is not, was Mr. Butler's settlement based on a meritorious claim? The question is, has the law upon which the settlement was based changed?
So, but just to unpack your effort to insert that point in there. So that, to me, goes to the questions we were exploring earlier about whether the board even has authority, right? So if you leave aside the merits of the constitutional argument, there'd still be the question of, can the board do something that, you know, perhaps the board no longer has authority to do? But that said, I do want you to address, you know, maybe we don't have to decide the merits of the constitutional issue, but just sort of explain why there's a logic behind that argument.
Absolutely, and I'll also address the court's second question, which is, does the board continue to have authority? This court in Rodriguez held that the inmates have a right to have proportional sentences, and that is under the state constitutional protection, Article 1, Section 17, and under the federal constitutional protection. At the time of Rodriguez, the board, as it is today, was claiming that it had no duty at all to consider proportionality in sentencing. And that's a very important point. That's what the board claims is the state of the law today. They claim that the legislature has reformed the law in such a way as to inform the board, and we don't agree with this reading, but as to inform the board that they have no need at all to consider proportionality. And indeed, my friend on the other side just told you that Lawrence held that there's no need at all to consider proportionality. That was the exact state of the law at the time of Rodriguez. The legislature had recently passed an amendment to the statute saying that at that time the board could fix a term or refix a term, and it had complete discretion to do so. It could even refix a term after it had fixed a term for an inmate. What this court said is the Constitution does not allow that. The Constitution requires that the board consider proportionality at the time of the parole release finding. And this court clarified that a parole determination has two components, one of which the board claims today that it can completely abdicate, that it can stop doing henceforth. There are two components. One is suitability, and we agree that suitability is a different component than term fixing. We agree with that proposition. And under Lawrence, it is an individualized comparison. But there's a separate component that the board has a constitutional duty to do. That's what this court held in Rodriguez. And that is to consider the proportionality of the crime into making a determination about when an inmate is going to be released. Rodriguez then held that the board had to make that determination for every inmate. Otherwise, when an inmate presented a habeas challenge to his proportionality challenge in a habeas petition to a sentence, this court would have to presume that the sentence that was being imposed was a life sentence.
You've now mentioned Rodriguez 3 times. What did we say in Dannenberg?
Yes, Your Honor. In Dannenberg, this court held that it was acceptable for the board to delay the calculation of base terms until after a suitability determination. But Dannenberg has now been abrogated by SB 230. Dannenberg was explicitly based on an analysis of 3041, Penal Code 3041, and now I'm referring to Penal Code 3041 as it existed in 2013. In 2013, Penal Code 31 had two components. It said the board has to set release dates based on uniformity, and the board has to consider the public safety. And what this court held in Dannenberg was that public safety, according to the statute, trumped the uniformity considerations. The legislature has expressly repudiated that particular viewpoint. That was the basis for SB 230. If you read the legislative history of SB 230 that is in the record in this case, what the author of the bill, Lonnie Hancock, and the legislature were concerned about was that inmates were being kept in prison too long, and that was leading to overcrowding. That is the express concern that was articulated at the time that SB 230 was brought to the floor, and that concern continues throughout the legislative history of SB 230. And what the board was what the legislature was very concerned about was that base terms were being used as a minimum term. The legislature did not understand why that was the case. It found it to be perplexing and confusing.
What is your response to your friend on the other side's argument that base terms are no longer necessary because the amendment to the statute said that minimum terms must be set?
That is a fundamental misconception of the role that base terms play. Base terms are not minimum sentences. That interpretation of base terms is an interpretation that was expressed solely by the fiat of the board. It was first expressed in 1979 in something that is referred to in the briefing as the Morrissey 8 memo. But that is not the origin of base terms. The origin of base terms is the Rodriguez case. After this court issued its decision in Rodriguez, the board issued Chairman's Directive 7530, which is a part of this record. 7530 is the origin of base terms, and what Chairman's Directive 7530 says is base terms are the mechanism by which the board is going to consider proportionality. They establish the board's attempt to assess whether or not a sentence is proportional as compared to other crimes.
I understand that argument, but it's not your position, I take it, that there are no other ways that the board can take account of proportionality.
We do not here argue today that the board doesn't have discretion in setting its regulations. We do argue, however, that the board does not have discretion to simply flout a consent decree that it agreed to. And the board was aware of this history and was aware of our constitutional arguments when it agreed to the consent decree.
Is it your position, let me just follow up on that. I take that point. Is it your position also that notwithstanding all the statutory changes that have occurred that are partly why we're here right now, the base term calculation and the role it plays is and can be essentially the same as when the consent decree was entered?
Your Honor, the board it was our position, and it continues to be our position today, that the board was misusing the base term when it used it as a minimum sentence. And that is the position that the legislature agreed with. The legislature said using the base term as a minimum sentence is confusing and opaque. We don't understand why inmates are being kept beyond their minimum sentence. And what's very interesting about the legislature's viewpoint is that the legislature didn't even appear to understand that that was occurring. Note that this court in Dannenberg expressly based its opinion on the conclusion that the legislature had apparently blessed the use of base terms as minimum terms to be set after a suitability.
Just so I'm clear, what you seem to be saying is it's yes, indeed, they will have to work differently now, but that's because the board was using base terms the wrong way to begin with, which is as a baseline minimum.
There's a little bit of nuance I just want to add to that, and I think this nuance is particularly important. There is nothing in the settlement agreement that requires the release of any inmate. We have never taken the position that if an inmate is beyond his base term, he is therefore entitled to automatic release. What the base term does accomplish, and why we believe it is so crucially important, is the base term requires the board to consider proportionality at the time that it makes a suitability finding. It does not bind the board. It does not mean that the board has to take a certain action, but it does require that the board consider suitability, and that is a requirement that was imposed by this court in Rodriguez.
How does the base term illuminate the actual focus of the suitability determination, which is the danger that the prisoner presently poses? What is the relationship between that proportionality analysis and the actual function of the suitability determination standing alone?
The court explained that relationship in Rodriguez and actually affirmed that same relationship in Dannenberg. The suitability determination is an individualized determination that does consider facts of the crime, but also considers conduct that occurred in prison. So it can never be a determination that is based on the sentence that is proportional to the crime. By definition, the suitability determination takes into account post-conviction conduct that occurred in prison. This court explained in Rodriguez that there is a separate determination that the board must undertake. If you're going to delegate completely the decision when to release an inmate from prison to the executive branch, then the executive branch has a duty to consider the constitutional considerations that underlie that sentencing act. And that second component is a proportionality component. The Eighth Amendment and Article 1, Section 17 require that an inmate not be kept for a term that is disproportionate to his sentence. So at some point in time, an inmate may have served a sentence that is unconstitutional. At that point, as Dannenberg explained, an inmate can no longer be kept based solely on public safety or suitability considerations.
But if the object of the suitability determination is just to evaluate public safety considerations, doesn't the proportionality analysis and the question of whether the sentence has at this point become constitutionally disproportionate really stand separate and apart from that function?
They are absolutely two separate functions, Your Honor. That's what the court explained in Rodriguez. What the board did before it entered into the settlement agreement was kind of conflate them. And it didn't clearly separate them, and it waited until after the suitability determination to really consider proportionality. Now what the board is taking the position, and it was expressed completely clearly today, and it was expressed with the same clarity in the Court of Appeal, they have taken the position that they do not have to consider proportionality, that it is totally irrelevant to the decision about when to release an inmate. And our position is simply that they ought to consider it. We're not trying to bind their hands. We're not calling for the mass release of inmates. We're saying, pursuant to your own agreement, you should consider that factor before you make the suitability.
Just to clarify, if we were, for whatever reason, not persuaded that base terms should continue to be required under the settlement agreement, what would be the status of the settlement agreement, and what would the board be required to do?
If So let me just make sure I understand the question. If this court were to conclude that the settlement agreement no longer requires base terms, or it should be modified,
Correct.
If this court were to conclude that
That a modification of the settlement agreement is appropriate to no longer require base terms,
then
what would be the responsibility of the board then?
then our suggestion would be to remand the case to the district court in the first instance. My friend on the other side did. I'm sorry, to the Court of Appeal. This is a different case in that the settlement order was entered in the Court of Appeal, not in a trial court, because the habeas petition was brought there, and that's where the order entered into, and the Court of Appeal retains jurisdiction to consider that order. One thing that my friend on the other side didn't talk about was that the standard that governs this case is an abuse of discretion. So if new findings have to be made about the appropriate scope of the settlement order, the best court to do that is the Court of Appeal.
What findings, and using that term in a factual context, what findings would have to be made or would have to be considered?
Absolutely, Your Honor. The parties actually agree. This may be a rare case in which the parties actually agree on what the legal standard is that the court is applying in this case. Okay? And I just want to read it into the record. It's also in the briefs. The parties agree that the legal standard is set forth in Civil Procedure Code Section 533. And now I'm going to read it, and there's some ellipses here, but I'm quoting otherwise. In any action, the court may on notice modify an injunction upon a showing that the law upon which the injunction was granted has changed. Here, in this case, we're dealing with a settlement order. And the board has cited to a couple of cases from the U.S. Supreme Court that ask whether that standard is applied. Now, your question was, Your Honor, what is the factual element of this? I would answer that this is a mixed question of law and fact. The question to be answered by this court is a mixed question of law and fact. Has the law upon which the injunction was granted changed? That law is the law that was asserted by Mr. Butler in support of his complaint. And for that, I can cite you to the board's own authorities. The board has cited two U.S. Supreme Court cases to help guide this court in its determination of what do you do when a party who's voluntarily agreed to a consent decree, what do you do when that party comes into court and wants to undo its prior agreement? What the U.S. Supreme Court did in System Federation, number 91, and in the welfare rights case was to look to the complaint. Well, okay, let's see what the cause of action was based on. What was the plaintiff trying to put at issue in this case? Mr. Butler's action isn't founded on a complaint, obviously. It was founded on a habeas petition. And in this case, the operative pleading is a supplemental habeas petition. His claims, as set forth in the petition, sought to vindicate the constitutional rights of inmates under the state and federal due process clause and the prescription against cruel or unusual punishment set forth in the Eighth Amendment and Article 1, Section 17 of the California Constitution. The Court of Appeals made a finding under this standard. The Court of Appeal found that Mr. Butler asserted a claim founded upon a constitutional right. That finding is what is at issue in this case. That finding is reviewed for an abuse of discretion. That's a factual issue. That requires the court.
What does it mean to say that there's a finding that his claim is constitutionally based? I don't understand the construct of that sentence.
Yeah, absolutely. And as guidance for how to implement that particular standard, I just again cite this court back to the board's own authorities, System Federation and Welfare Rights. How did the U.S. Supreme Court make that determination? It looked to the complaint. This case doesn't involve a complaint, so we look to what I suggest that the court look to is the operative pleading, is a second supplemental habeas petition. And the board has argued, well, that's not the right place to look. The operative pleading is not the right place to look. Instead, we recommend that the court look to the stipulation. That's not what the courts did in the U.S. Supreme Court cases, but even if you look at the stipulation itself, the board stipulated that Mr. Butler's supplemental habeas petition was, and now I quote, a systemic constitutional challenge to the board's term-setting practices. The board wants to argue today and have this court make a finding that our constitutional claim has no merit. That is exactly the right that it gave up when it entered into a settlement agreement. If the board wanted a court to rule that our constitutional claim had no merit, it had the full ability to do so, and that was to proceed to a final judgment. But it decided not to do that. It decided not to do that. It decided instead to agree into a voluntary settlement agreement. This now, here, before this court, is not the appropriate forum to relitigate the merits of Mr. Butler's constitutional claim.
Is it the appropriate forum to determine whether there's been a material change in the law?
Absolutely. Absolutely, Your Honor. That's the question that this court, that the Court of Appeal...
You don't have to give any deference to the Court of Appeal in determining whether SB 230 affects a material change in the law.
No, Your Honor. I disagree on that point. This court has made it absolutely clear that the standard of review is an abuse of discretion. And I posit to this court that the legal standard that the parties agree upon requires this court to answer a mixed question of law and fact. And
but if the discretion exercised by the lower court is at odds with legal principles, then that itself is an abuse of discretion.
I think what Your Honor is saying, and I might not disagree with it if this is what Your Honor is saying, I believe that perhaps what Your Honor is saying is, if this case rested on a pure issue of law, this court would review de novo, and this court would be the final arbiter of what California law is, statutory or constitutional. I don't disagree with that, Your Honor. But what I am saying, though, is that's not the question that is presented to this court. That question, an attempt to relitigate the merits of Mr. Butler's claims, is there a constitutional right, is there not a constitutional right, is it a meritorious claim, that's not what's before this court.
But then aren't you essentially getting to that this court should vacate the current order, let the case remain in the Court of Appeal for whatever further habeas proceedings the parties believe are relevant on the issue of further constitutional issues? But it doesn't suggest that the order should not be modified, or the order should be modified, but should be vacated.
Absolutely not, Your Honor. There is no need for this court to vacate the settlement order. There is no need for this court to do that. SB 230 and SB 260 and SB 261 do not conflict with the settlement order.
But aside from the responsibility the board has under the settlement order to conduct the base term calculation and to do so at the time of the initial suitability hearing, what responsibility does the board have? Does the order specifically impose on the board a separate responsibility to engage in something to assure that there is no constitutional disproportionate sentence imposed?
The settlement order itself is very modest. All the settlement order requires is that the board issue base terms to inmates at their first suitability hearing, that is to calculate them. The board in this court and in the court below has complained of burden. First of all, there are 0 changed facts involved in the burden. Second of all, in other words, when the board agreed to the settlement order, it fully understood the burden it was undertaking. Nothing about the nature of base terms has changed that could possibly justify unwinding the settlement order now. They knew that the burden they were agreeing to, and they agreed to it. So they're not arguing changed facts in the nature of burden. Second, on the burden, the board has admitted here, and it admitted below, that calculating the base term is not very burdensome. I sat through the calculation of a base term. The board has a computerized system of software that every parole commissioner has, into which they enter a series of numbers. It basically operates as a form.
But the reason you care about, the reason you care about base terms is as a means to an end to prevent constitutionally disproportionate treatments.
Absolutely, Your Honor. That's absolutely correct. And I do just want to talk a little bit about the authority, because there's been some suggestion that the board no longer has any authority to calculate base terms.
And
Could I, before you go there,
Yes.
just ask, so I'm trying to follow the analytical train of your argument, and you say that this is not the forum to decide the constitutional issue. I may agree with that, but Justice Rubin asked, we are here to decide whether there's been a material change in the law, right? Don't we have to do some analysis of whether or not SB 230 alters the level of constitutional risk that underlay the initial settlement? So the risks, as you began your argument, you said both sides face risks. So one important question would be, do those risks look the same in light of the change in statutory law that exists today? And that's, I know these are very fine distinctions, but that is not quite deciding the constitutional issue, but it is trying to understand whether or not the parties are in a different position now than they were at the time.
Yeah, and Your Honor, I understand your point, and I disagree with it. I do not believe that this court is charged with looking at have the risks of what the litigation would be, have they slightly changed now because of a statute. I do not believe that that's the legal standard this court is being asked to apply. The legal standard is has the law upon which the settlement order was granted, has it changed? And when you look at the cases that have applied that legal standard, both in this court and the U.S. Supreme Court, they answer the following questions. Has a statute upon which a consent decree or an injunction, has a statute that granted that right, has that statute been repealed? If that statute has repealed, does that create a tension with a pre-existing constitutional right? They don't simply ask, have the litigation postures or the litigation risks slightly changed. That was a decision for the parties to make. And what the board has admitted, and what it admitted below, is that there is no direct conflict between SB 230, SB 260, and SB 261 and the consent decree. That was an admission that was made in open court, and we cited in our briefs. Nothing in SB 230, nothing in SB 260, and nothing in SB 261 prohibits the board from calculating base terms. So the plain language analysis is clear. That's clear. There's nothing express in those statutes that conflicts with it. So then you look at the legislative history to try and get a better understanding. Well, okay, what was actually animated? The legislature, when it passed these statutory reforms, what was behind it? The legislative history is resoundingly clear. The legislature was concerned about overcrowding. Orders had come down from the Brown versus Plata court and from the U.S. Supreme Court saying our prisons are suffering from overcrowding. And it appears to us, the legislature, that inmates are being found suitable for parole, but are being kept until their base term. We literally don't understand that. We find that to be opaque. We find that to be confusing. It appears, they don't say this expressly, but it appears that the legislature was even unaware that this was occurring. And then in the legislative history, repeatedly, in the Senate floor analysis and in the Assembly bill analysis, the legislature says over and over again that we don't approve of that. That doesn't make any sense. In other words, base terms should not be used as the minimum terms.
Can I ask you a question about SB 230 and the changes in the law?
Yeah.
I understood that the argument on the other side is that change in the law deprived the board of the authority to set the base term, and that the base term has now become irrelevant for purposes of ISIL sentences due to changes in the law. Usually we presume that when the legislature acts, it's aware of case law, it's aware of laws, and yet when the legislature withdrew that otherwise requirement, didn't change it into a may, are we supposed to believe then that the legislature knew of the consent decree and the consent and the stipulated order, and then still knew that by passing this law that they had the expectation that the board would be continuing to calculate the base term and using state funds to do so?
Absolutely, Your Honor, and here's why I don't think that that's an unfair assumption. In the first Assembly bill, in the first Senate Public Safety Committee analysis, which is in the record in this case, Senator Lonnie Hancock, who is the author of the bill, submitted her analysis of the bill. And it was the Committee on Public Safety's analysis of the bill. And she does refer to the Butler settlement in that. Nowhere in the legislative history does the legislature say we're trying to undo the Butler settlement, we're trying to make sure that its effects no longer have any provision. So yes, the legislature was aware of the In re Butler settlement, and they did not say either in the legislative history or anywhere in the statute itself
And
that...
so they didn't change it to may still calculate? They eliminated the authority of the board to calculate that? Are there then, assuming the board acts through its delegation and acts through statute, I just wonder how the board is able to calculate, have the authority to calculate if that authority has been eliminated.
Yes,
Do they
sir.
do so through regulations? And if so, where do those regulations stem from?
Yes.
What is the anchoring statute if it doesn't exist any further?
Yes, absolutely. So that was a question I wanted to address, and I hadn't yet gotten to it, Your Honor. First of all, the authority to fix terms and the authority to consider proportionality comes directly from the Constitution itself. And this court in Rodriguez already held that the board has a duty to consider proportionality and that it does exercise that duty through term fixing. But I'll just point you to California Penal Code Section 3052. That gives the board more than sufficient authority to promulgate base term regulations. It provides that the Board of Parole hearings shall have the power to establish and enforce rules and regulations under which inmates committed to state prisons may be allowed to go upon parole outside the prison buildings and enclosures when eligible for parole. Moreover, the settlement order itself gives the board authority to calculate base terms. The settlement order is a binding order of the court.
Well, let me leave that argument aside. That may or may not be persuasive, but just to focus on your point, the first point you made. The reason we keep going back to this awkward place where I think you don't want us to go, which is like, what is the merit of the constitutional argument, is in part because to the extent that that is one potentially important argument, it's the first one you mentioned in arguing that the board has authority to continue to calculate base terms, we have to weigh whether the board is potentially constitutionally required to do so. That's not the main point of this case, but it does seem that your argument somewhat uncomfortably leads in that direction.
Well, there is a little bit of nuance in my argument, and I just want to explain.
There's a lot of nuance in your argument.
And I want to explain what the difference is. This court does need to decide the law upon which the complaint was founded, and we explained that that's a constitutional claim. And so that question is before the court. There's a separate question, I think, which is, if this court were to resolve the constitutional claim in the first instance, would it produce an order of its own power that is the settlement order? It is our position that there is a meritorious claim for that. But that second question is one that this court does not need to reach, and that's the nuance.
Did it not weigh in the parties' thinking at all, do you think, or even in the courts, that at the time the settlement order was entered, the board had an explicit responsibility to calculate base terms?
I can tell you, Your Honor, that we never, Mr. Butler, never sought to make a statutory claim. And the reason...
That's not quite my question. I understand
Okay.
that point. But even the use of the term base term suggests that there was some reliance, perhaps, on a practice that the board was engaging in that the board could point to having some specific responsibility to do.
No, Your Honor. And let me tell you why Mr. Butler never sought to assert that claim. We read Dannenberg, we understood that Dannenberg was binding, and we were not about to make a claim that the statutory language of 3041 required that base terms be calculated before a suitability finding. That was the law of this court based on the statutory analysis, provisions which have now been repealed. So we never intended to assert that statutory claim. Our claim, we believe, and
You keep asserting that you didn't intend to assert the statutory claim. Whatever your intent was, the language referring to the base term is in the agreement, is it not? It's hard to argue around that.
I'm not totally sure I followed the question, but so yes, we do refer to the base term in the settlement order. It's referred to in the stipulation and the order itself. There's no part of the order that cites to a statutory authorization for the
That's the read on which you are standing, that there's no reference to the specific statute that talks about base terms?
Your Honor.
So you used the term, which I assume you didn't just pluck out of the air.
No, Your Honor, the word base term never appeared in the statute.
I beg your pardon?
The word base term did not appear in Penal Code Section 3041.
Let me be clear.
Yes.
I'm asking about what is in the stipulation and
Yes.
the order.
Yes, Your Honor.
Does the order make reference to base terms?
It does.
Thank you.
Absolutely, Your Honor.
So, Mr. Jacob, I'd give you another 30 seconds to wrap up your final thoughts, but your time's expired.
Thank you, Your Honor. Just to wrap up here, I want to make clear that this is a real issue. This is a real issue that affects inmates in prison today. There are, at the time of Mr. Butler's supplemental habeas petition, there were approximately 20,000 inmates who were classified as low risk, 20,000 life-term inmates who were continued to be in prison. Approximately 9,000 of those had served beyond their minimum eligible parole date. So there are dozens of inmates who will benefit from having their base terms calculated. Thank you for your consideration, Your Honor.
Thank you, Mr. Jacob.
Counsel, does the board have a responsibility to consider proportionality?
No, it doesn't, Your Honor.
Constitutional or statutory? No responsibility.
It does not. The statute directs the board to consider public safety as the exclusive consideration for suitability.
The statute does, but your position is that constitutionally there is no need to consider proportionality under the federal or state constitution?
That's correct. In Dannenberg, this court specifically held that the concerns that were at issue in Rodriguez no longer applied after the legislature repealed the indeterminate sentencing law and adopted the determinate sentencing law. And that's for a number of reasons. First and foremost, after the DSL was adopted, life sentences were reserved for only serious violent offenders. At the time of Rodriguez, many felonies were subject to possible life in prison, including very low-level offenses. Also, under the current statute, life offenders have an expectation of parole after they've served a minimum term set by statute unless there is reliable evidence of dangerousness.
And life offenders cannot conceivably advance a proportionality claim?
Your Honor, in Dannenberg, this court said that the constitutional limitation on excessive sentences will rarely apply to the serious violent offenders who are subject to life sentences. But in those, if there is a particular case where an individual believes that his sentence has exceeded constitutional bounds, he has an available remedy, and that is a habeas petition. And that remains true today. The Constitution doesn't require the board to add to that system a base term calculation or any kind of fixed maximum term to bring the system within constitutional bounds. It already is within constitutional bounds. I do want to address my friend's observations about what the standard that applies to a modification request. And it is not correct that the court should focus only on the law that is pleaded in the complaint. The inquiry looks at whether there has been any material change in law or whether continued enforcement of an injunctive order is no longer in the public interest or is no longer necessary or desirable. And the U.S. Supreme Court in the Horn versus Flores case directed courts to look at all manner of changes of law, state and federal. That's also in the David B. case and the Court of Appeals decision in Welsh. And so the inquiry is not confined to how Mr. Butler styled his complaint. The inquiry is also not confined to asking whether the stipulated order is illegal. The question is whether there have been material changes to the law that make continued enforcement no longer necessary or desirable. The other point I wanted to raise was regarding what specifically this court should order. There is no need for a remand in this case. There are no outstanding factual issues. The Court of Appeals ruling denying the board's motion to modify rested on two legal conclusions. First, that SB 230 did not materially change the law, and second, that base terms have a constitutional dimension. Those are legal conclusions, and we respectfully submit that each of them is erroneous. The last thing I would like to discuss is also in regard to the constitutional question. Mr. Butler has argued that the constitutional considerations require the board to continue to be bound by the order. For the reasons I've described earlier, that isn't correct. But I also want to make clear a point that my friend made about the origin of base terms. Base terms under the statutory and regulatory structure adopted in the DSL have reflected and have always reflected a minimum term. The legislative history of SB 230 makes clear that the legislature understood that that was precisely what the statutory and regulatory framework, how that framework defined base terms. There, at the time of Rodriguez, after Rodriguez, the board implemented the duty to set fixed constitutional maximum terms by setting what it defined as a primary term. And that was defined to mean the board's judgment of the constitutionally proportionate sentence. In calculating a primary term, the board first computed what it called a base term. That language reappeared in the regulations that the board adopted after the DSL, but the term was used in entirely different meaning. In the regulations adopted under the DSL, base terms were defined to express a minimum term. So while the language base term did appear in the post-Rodriguez ISL regulations, it had an entirely different meaning. And it would be incorrect to suggest that the semantic similarity between those terms has any substance. It does not. They are entirely different terms. The last point I will raise, Your Honor, is that Mr. Jacob mentioned Penal Code Section 3052. That is a general grant of authority to the board, but the suggestion that that would permit the board to continue calculating base terms overlooks the fact that in SB 230, the legislature specifically repealed the specific authority to set parole release dates. And the stipulated order should be modified to be consistent with that legislative judgment to eliminate the board's term setting role and to empty base terms of any meaning or function. And if there are no questions, we would ask the court to reverse the Court of Appeal, order that the stipulated order be modified, and make clear further guidance for lower courts and litigants that base terms do not have a constitutional dimension. Thank you.
Thank you, Ms. Feinberg. Mr. Jacob, the matter submitted. We stand in recess.